Good afternoon. Thank you so much for joining us today. Patrick Gorman is leading today's training on consolidation as a strategic solution to litigation cost expansion. We have Louis Laris and David Majubi joining to assist Patrick with questions today. Tamina Ahmed and Don Barthel are also joining in today's fun.
Thank you, Tammy. Good afternoon, everybody. Welcome to our complex litigation department's consolidation seminar webinar. We have been having amazing success with this division, and we invite all of you to check it out. We will be posting more information about this division shortly. As some of you know, my name is Tamina Ahmed. I've met you, I've worked with you, I've had the pleasure of seeing you all in the past 25 years, almost 25 years that I've been with B&B. And I look forward to working with all of you guys again in the future. I hope everyone is staying safe, and we look forward to meeting everyone in person as soon as we can. Thanks so much. And with that, I'm going to pass it off to David Majubi.
Thank you, Tamina. My name is David Majubi. I'm a partner in our Anaheim office. I've been with Bradford and Barthel now for 10 years and primarily cover the Orange County and LA area venues. But as you know, with remote appearances now, we are able to handle pretty much just about anywhere in the state of California. Personally, I specialize in complex lien litigation. And as you may well know, there's a lot of non-IBR petitions that have come to light, which I have dealt with extensively. And I've had the privilege of working with Mr. Gorman as well as Mr. Louis Laris from our appellate division on some of these cases. So if you have any of these types of cases, non-IBR petitions or complex lien litigations that involve pesky lien claimants, please keep our firm and myself in mind. With that, I'd like to turn it over to Mr. Louis Laris.
Thanks, David, and good afternoon, everybody. As David said, my name is Louis Laris. I'm an equity partner with Bradford and Barthel. I've been with B&B for just over 20 years, and I'm located in the Fresno area. We cover the Bakersfield and Fresno boards, and I also head up the appellate division with Bradford and Barthel. I started the division, almost 10 years ago now, after a little case called Alvarez-Guzman or Guzman, in which I participated along with Don in arguing that case before the 6th District Court of Appeal in San Jose. I've argued numerous cases up and down the state at various district courts of appeal and even the Supreme Court. I'm happy to be here with you today and to share my insights along with Patrick and David, and to give you that 30,000 foot view perhaps from the appellate perspective as well. And with that, I'll turn it over to Don.
Thank you, sir. Louis actually is the most sophisticated, most experienced attorney when it comes to workers' compensation appeals and recons that I know in the state. So if you have any questions, please take advantage of his expertise. Remember that we've got offices everywhere throughout California, and our 100+ attorneys represent defendants throughout California and Nevada. I want to thank you for finding time in your busy schedule to learn about this fascinating topic that's well, it's pretty much invisible to most of the industry. Consolidation as a strategic solution to litigation cost expansion. For many, this area of the law is a riddle wrapped in a mystery inside an enigma, to quote Winston Churchill. I believe that Patrick Gorman will provide the necessary keys to these issues to unlock them for you. I think the sophistication and the cutting edge nature of today's topic just exemplifies why Bradford and Barthel has a complex litigation department. That department offers consultations and representation on strategic litigation solutions. And if you run across a particularly complex matter, please contact Patrick Gorman, and I think he can provide a solution. In addition to leading that up, he is also the managing partner of our Reading office. I want to draw your attention to the BMB blog. We publish articles every 1 to 2 weeks with legal updates on such things as the labor code, regs, executive orders. We've seen a few of those lately, case law, industry trends, and the like. And you can access those on our website at bradfordbarthel.com. And you can also get on the BMB mailing list by sending an email to Tammy, and she'll get those newsletters out to you on a regular basis. All right, that's about all I have to share, but I do have a reputation as a bad joke teller, and today should be no different. So let's get that out of the way, shall we? Two lien claimants are two lien claimants are driving down the road at an incredibly high speed, and they pass a pickup truck with a couple, Ma and Pa, in there. Look at them fools, Pa. Must be a couple of lien claimants, and they surely will meet their maker, I tell you. Well, sure enough, the good couple comes around a corner and sees a bad accident involved with the two lien claimants. Well, Ma, we got to do what any good folk could do and give them a decent burial. So the couple digs up a hole and buries them. Just as they're putting away their tools, a police officer drives up. Did y'all see this accident? No, sir, but we knew them dang fools are going to have it when they passed us doing 100 miles an hour. Well, we comes across the accident, and we gave them lien claimants a decent burial. Were you sure they were dead? Well, they said they weren't, but you know how them lien claimants exaggerate. All right, but okay, at least it was fairly original. Let's get on to the important stuff. Without a further ado, Patrick, go. Let's learn us, please.
All right, thank you so much, Don, and good afternoon, everybody. My name is Patrick Gorman. I'm in the Bradford and Barthel Reading office, but I do have experience across multiple venues. I did work in our Oakland office, now the Concord office, for several years prior to relocating to Reading. So I have a lot of Bay Area experience, but again, more recently, multiple venues and working with our COVID response team and now in the complex litigation sphere. So before we jump into everything, this is going to be a little different. It's heavy on strategy and light on law, because what we're talking about now are business considerations. And if you haven't had enough thrown at you over the last year between multiple executive orders, statutory changes rushed through on a expedited basis, presumptions, and prompt determination timeframes, we're now going to throw some other things your way, because there are industry trends that you're going to need to adjust to, especially on a claims management level. So first, when we talk about complex litigation, I mean, cases can be complicated. We have large loss cases, things of that nature, difficult QMEs, difficult AAs, and that's not necessarily what complex means when we refer to complex litigation. Complex litigation involves novel issues, multiple jurisdictions or venues, and multiple parties. So complex litigation means it's a fancy way of saying something that's ripe for consolidation and presentation to one judge, and it's favored by the courts, not just the Workers' Compensation Appeals Board. So long as it isn't used for an improper purpose, such as delaying the inevitable outcome of a case. You consolidate 100 bad cases just so that the other side can't force you to trial. That's not going to be consolidated. It wouldn't be right. Or if the consolidation severely deprives one party of a due process right, which is not as likely, because you can always bifurcate issues. But typically people argue, if they're resisting it, that it somehow steps on their rights, or that it's being done for an improper purpose. And we've been on both sides of this. Typically the more traditional consolidation is you have one employer with multiple carriers or multiple employers over one CT period, and you have some doctors that don't agree with one another on apportionment. So one party wants to consolidate because they want their doctor who's favorable to them to apply to all injuries, and somebody doesn't want to consolidate. And that's the typical nutshell of where we've seen consolidation. But things have changed. Before we get into that, though, this is statewide, and class action lawsuits are a very prime example of a complex case. And the rules of court have been promoted by the Supreme Court, providing guidance in those cases. And the reason why is it's unduly burdensome on the courts to hear the same dispute hundreds of different times in front of hundreds of different judges. So the Supreme Court has provided rules designating what a complex case is. They do have special rules applying to them that aren't applicable to workers' comp, but just to illustrate the favoritism towards complex case designation, I did want to include this, that the California rules in court do recognize complex cases when there are multiple parties, things of that nature. So the Supreme Court has stated these factors are present and weighed when designating cases as complex. And, as novel issues, multiple pretrial pleadings, multiple parties across multiple venues, things of that nature. And with the California rules of court, they also have, there are companion cases, multi-jurisdictional cases across state lines, and even federal jurisdiction. But in a nutshell, the complex case designation is for the purposes of preventing inconsistent findings. And again, it's not a mistake that Lewis is here today to help answer questions, because typically these are matters of first impression or matters that are going to have a high probability of appeal in second review. Also, the post-judgment judicial supervision isn't necessarily for the final finding and award in a case, but the interim orders, discovery orders, and things of that nature, evidentiary orders. If you have a party that continuously obstructs discovery across multiple venues and you're trying petitions to compel across several different judges and hearing calendars, that makes no sense. The courts are having their resources wasted, if you will. One order should be as good as 20 because the law is the law. And the inconsistency in findings also is a real problem when you're trying to argue res judicata and prevent second, third, fourth bites at the apple and relitigation of the same issue. How does this apply to workers' compensation cases? Well, we do have a complex litigation pathway in workers' compensation. We have a consolidation rule that was promulgated by the administrative director. And again, as I mentioned before, this is widely used when we're talking about a CT with multiple employers, or a CT with multiple carriers and one employer, and you have dueling reports and people want to strap the other party with a finding, things of that nature, or when you're dealing with restitution and contribution, things of that nature, which are much more simpler. But all the same, the regs do touch on what I'm discussing, which is a large enough number of claimants against one party, or one claimant against several parties, things of that nature, where you don't want to be fighting the same fight 300 times in 300 different locations across 150 attorneys, right? You want to whittle it down. You want to provide yourself with some predictability and control. So the board, the AD rules provide consolidation as appropriate. It's within the total discretion of the judges of the board. You're looking for common issues of fact or law. It doesn't have to be every case has the same exact set of facts, but there has to be some commonality to argue that you don't want inconsistent findings. Complex cases, matters of first impression, certainly are ripe for consolidation. Had the board operated back in 2008 during the Alvarez, Guzman, and Ogilvy issues, they may have consolidated those cases in front of one judge rather than across two, 3 judges, things of that nature. It would have been more orderly. They do need to weigh the potential prejudice to parties. Keep in mind, with workers' compensation versus superior court, we're talking about expedited provision of benefits. So if a party is going to be able to make a valid argument that somehow consolidation is going to delay their client's entitlement to benefits, that's going to be something the board will consider in determining whether or not consolidation is ripe. So in those instances, you can always bifurcate. You can bifurcate parties, or you can bifurcate issues on the consolidation front to assure the board, if you want the consolidation, then that it will not deprive a party of due process rights. I do also want to preface this with saying and just acknowledging there are going to be several times we don't want a consolidation. And so if you don't want a consolidation, your argument is going to be that your rights are being stepped on somehow, right? That inadmissible evidence is somehow going to be admitted into your case, things of that nature. but primarily the board wants to involve inconsistent orders. It prevents them from issuing inconsistent panel decisions and reviewing things en banc, and it provides more orderly provision of benefits and things of that nature. Before the Calamonica decision, for example, Mr. Majubi mentioned the non-IBR petition front, and I do want to say it's not a mistake that the board issued Calamonica en banc. There were two inconsistent panel decisions and a lot of uncertainty in the industry from 2015 until Calamonica was issued at the end of 2019, because one party would argue the Harbor Freight Farms case and the other party would argue the alternative case. And there was just uncertainty, and the board didn't know what to do. Trial judges essentially could follow one or the other, and we just had a lot of inconsistency, which increased litigation. So consolidation is favored to avoid these duplicative orders and also the efficient utilization of judicial resources. Now with the board being remote and parties not attending in person, they can spread calendars across the entire state. They can spread calendars to judges without impacted calendars. And the board has even gone so far as to allocate a lot of cases to a special lien hearing calendar, to the special adjudication unit. So with Senate Bill 863, there were some revisions to the labor code that tried to crack down on provider fraud. Those statutes were primarily focused on suspended providers, medical providers specifically, who were compounding medication, performing unnecessary procedures. They were being suspended and indicted, and they were still trying to collect. They were spinning off their collectibles, selling them to a company they themselves owned, and still trying to collect on the services despite them being suspended for Medicare fraud and things of that nature. So the legislature did invoke some laws, some statutes, in order to help freeze or stay all of those proceedings, to cut down on the boards just being sapped from responding to these multiple liens that weren't recoverable, and that insurance companies were settling for token value because they didn't want to pay the litigation costs. So the stay of proceedings was invocated by these statutes, 4615 and 139.21. But in those statutes, they also gave the administrative director the power to address these types of issues, not specifically for suspended providers, but any suspected fraud under a special lien proceeding. And so the administrative director formed the special adjudication unit, and that unit was bogged down for several years. Cases would go there and freeze and never move. They added a lot of judges to that special adjudication unit recently, and now they have a special adjudication calendar spreading multiple judges at multiple district offices.
Okey-doke.
And while there's no statutory authority for non-suspended providers, non-indicted providers, the administrative director has extended the special adjudication unit calendar to even cases involving suspected provider fraud. And we have seen a non-provider suspended provider calendar emerging at the SAU. They have two calendars now, one for suspended providers and one for other consolidations. And what we're seeing is a lot of copy services appearing on those other consolidation calendars. And these are, one carrier has a consolidation involving, over 1,000 cases, and more will join in. So that's a special note. The Department of Insurance also does chime in on consolidation, not directly, but indirectly. And this is an industry trend that we're starting to see emerge over the last 2 months, and it's largely broker driven. And so the WCIRB has promoted some rules stating that a catastrophe is a single incident resulting in compensable injury to two or more persons. And then they also go on to state that an accident includes incidents where multiple claims have been consolidated for hearing. And this dates back to 1993. And I'll briefly talk about the Cherokee International case before the Department of Insurance. But essentially you had an INS sweep at a production facility where they identified 26 or so individuals who did not have a lawful right to work and ordered Cherokee International to terminate their employment. So Cherokee International complied with the lawful order, and they were hit with 26 post-termination site claims. In that case, Cherokee International consolidated all of those claims on the post-term defense, or whatever it was in the form it was in 1993. I know it's changed since then. And they tried to argue, or they tried to convince the WCIRB that it should be reported as one claim, not 26, because of the disparate impacts on their X modifications. In Cherokee, they appealed because they lost, and the appellate level Department of Insurance commissioner said, no, this may not be an accident in the truest sense of the word. It wasn't a mass casualty event, but it was an accident, and then it wasn't intentional. They didn't have a choice but to let these employees go. And so we're going to allow it to be considered a catastrophe. So on Appendix 1, Paragraph 4 of the WCIRB reporting handbook, they do provide definitions consistent with the Cherokee decision, and the Department of Insurance has found this to be precedental. So you will find, especially as times get tough and you have COVID layoffs, that brokers and employers are going to be asking for these types of considerations to be evaluated to determine whether or not a wave of post-term claims is ripe for consolidation. And that's why we're talking about, among other reasons, the strategic considerations in deciding whether or not that's something that makes any sense. On one hand, the employer is going to want the lower X mods, but on another hand, there's other considerations that they need to weigh in on and think about in doing a proper cost-benefit analysis. So there are multiple benefits, and I think that consolidation in the right case is absolutely the pathway to take. And I've done this for several clients, both self-insured and not, when dealing with bad faith providers or multiple claims that were filed post-term on a site where they didn't work there for 6 months, things of that nature. It does allow you to streamline discovery, especially with bad faith provider actions. They are not going to cooperate with discovery. You're going to need several discovery orders to compel discovery. They will not produce witnesses. They will not cooperate. So streamlining discovery across one or a team of attorneys versus multiple attorneys in multiple offices at multiple jurisdictions is a huge benefit to consolidation. The more cases, the better. If you have 1,500 cases, you want fewer attorneys. You don't want 1,500 attorneys arguing the same discovery motions in front of various judges. It's just not efficient, cost-wise, time-wise, or any other in any other matter, and you wind up settling cases that aren't really valid cases just to avoid the fight. Cost spreading across multiple cases and claims with non-allocated costs, it's not as much the same consideration, but you are helping clients out if you don't have a catastrophe type situation, but you do have a large consolidation. You can spread discovery costs across multiple claims instead of one claim number, and that should help them on experience modifiers as well. One trial across multiple cases on a common issue is a huge benefit. It provides certainty, or not certainty, but at least predictability to case outcomes. It provides you with taking testimony one time from one witness instead of 30 times from the same witness. And it allows you to really go forward once on the common issues. And that's a two-way street, right? It's a double-edged sword. While it can benefit you, it can also hurt you if you have a bad case, right? If you have bad facts in law and the other side consolidates on you, they only have to have one trial to win on all issues, on all of them, right? You also have the doctrine of res judicata, which I mentioned earlier. You don't need an en banc decision to provide this judgment applicable to the same party. So specifically with providers, they might lose at one district office and win at another. So that prevailing order is not precedental. It is not res judicata. If you have one win on 300 cases against that party that you're defending against, you have a better argument that this decision is binding against them in all future cases without having to wait and beg the board for an en banc decision that they may or may not offer. So to the point, one trial in 40 cases is substantially cheaper, less cost, and more controllable than 40 trials in 40 cases and in front of 40 different judges. You have more predictability, more control over discovery, more control over strategy, and ultimately you only have to go to trial once. There's other strategic benefits that I mentioned earlier. This special lien tribunals, we all know the business model of these bad faith providers is to fight over recovery below the cost to go to trial. You have a $2,500 claim on a $90 invoice, and it's going to cost you $5,000 to try the issue. They know they're going to squeeze more than their $90 invoice out of the issue, because most people aren't going to spend $2,000, or they're not going to spend $5,000, $7,000, $8,000 to go to trial over a $2,500 dispute. So ultimately, this nullifies that leverage. This eliminates it. When I first did one of these back in 2016 against a coffee service, we were consolidated and put in front of Judge Cole and Van Nuys, and immediately that provider wanted to talk settlement at more reasonable values instead of trying to piecemeal these out and try them one at a time. So eliminating that litigation cost leverage is a huge benefit when dealing with the bad faith providers. They may not be insurance fraud every time, but we know their business practices are suspect, and we know that they hide behind litigation costs in order to get money they're not entitled to. Also, the judges, if you get in front of the special adjudication unit, if it smells like fraud, it will, you get one judge who's specially trained to deal with provider fraud issues. The special adjudication unit judges, they are not buying the usual arguments that these hearing representatives, not even attorneys, make in front of these trial judges who just don't want to deal with it. I mean, we know that a trial judge at the district office, they want to award benefits. They don't want to deal with a dispute between two corporate entities over $2,500. And they all but say as much. I mean, they don't say it in their orders, but they tell the attorneys as much. They say, counsel, your client is a huge company. We're not going to trial over $2,500. Settle it. So that eliminates that factor and the pressure to settle a case that we don't want to settle. It also stays all matters. So when you consolidate, you also request a stay, and they can no longer bring you into the various district offices to try to collect. It stays all collection efforts until the underlying issue is resolved. So it makes them much more willing to settle if that's what you want to do, or go to trial on the merits and get some kind of lasting judgment that you can bring back up if they try to relitigate the issue they lost on. The consistency of discovery efforts is very beneficial. As I said, you're going to have overlapping patterns and facts, and you can't show a pattern if you're taking one case. If you have one case and you want to bring in patterns from 36 other cases, it's going to be argued against and potentially disallowed because those cases aren't relevant to your current case. But if you have your 36 cases and you can show that pattern, it is a better method to do that. I do want to say, though, that the discovery costs, depending on the complexity of it, at some point you need to involve either your internal civil litigation departments or hire out with a third-party vendor to run analytics and collect the massive terabytes of data that you might be looking at collecting. And again, we have reached out to vendors. We do know vendors who specialize in this and can help in that regard if you want to facilitate that. So instead of negotiating these invoices based on your litigation cost considerations, you actually don't have to do that with the large consolidation. And I'm certain that if every claims supervisor or team manager in here looked internally at all of their caseload across all of their claims team, they would find dozens and dozens and dozens of cases where this was occurring and multiples of six figures annually. Which brings up another issue. It can be very complicated internally to just generate a case list. And again, we work with clients to do that. It's very complicated, and every client's going to be different depending on their internal database and software systems and who their review vendors are. Next, the strategic benefits that I referenced with the savings to employers and the impact to them. 132As and serious and willful allegations, again, it saves them on that. But the experience modifier impact is a huge benefit, and you're going to be hearing more and more from the broker side on this. We've been seeing it emerge more over the last couple of months. But it does also provide the employer, the client, with better control over trial judges. And I don't mean control over the trial judge like you can tell them what to do, but you can strike a trial judge who you do not believe is going to be impartial. And you can strike them across the entire case, not just one case at a time. There's also several hazards, as I mentioned, and these are all things that you really need to consider when determining whether or not your consolidation is in fact strategically sound. I would never advocate or say that any case involving multiple claims or cases across the same provider or the same applicant's attorney should be consolidated, because it can really be harmful as well. Specifically, if you have a bad set of facts or a law that are common, For example, a post-termination defense across multiple claims where these are all long-term employees in a heavy industrial job, you're going to lose all of them in one trial, and you're going to lose any leverage to settle these cases early. So bad facts are law. Definitely you need to consider that as a hazard and determine whether or not consolidation is right in these facts. And you're going to get pushback from your client potentially because all they're thinking about is the experience modifier impacts, not the overall costs of the outcomes, especially if they're no longer a client or if there's if we're talking about allocated and non-allocated costs. Also, we need to consider whether or not the industry dives into complex litigation wholesale if that starts giving ideas to CAW. And we really want to avoid class action emergence. We don't want applicants' attorneys sending their employees or their friends out to everybody's house when there's a large plant closure at some huge facility and signing people up to file applications. We already know there's capping. We already know it happens, but this would just encourage it further. So we need to consider that as a potential hazard as well. Also, we need to know that when we consolidate and there are multiple applicants' attorneys, they're not going to be very happy about it if they lose home court advantage. They want to pick their venue because they know the judges and they want to work with those judges. Specifically, I've never practiced in Marina Del Rey, but I've heard all of these horror stories about the hometowning there. I know some people have a belief that there's hometowning in Reading. I haven't seen it so much, but any applicant's attorney is going to not want to lose that home turf advantage, which I think will be less of a valid argument given the remote appearance calendar now that will probably stay in place in some way, shape, or form indefinitely. But they will resist, and you might have to file responses to objections and removal petitions. Also, keep in mind that you're going to slow down the trajectory of all of the cases. It's only going to move as quickly as the slowest AA. And everybody's had that case in one venue. There's always an attorney in any venue who will never let a case go forward. They won't give you a settlement demand, but they also won't let the case go to trial. They always have something else to do that they never mentioned over the last 4 years. And if you have one of those attorneys in your consolidation, that's going to be true for all of your cases if you actually want to go forward to trial on the issue. So I included this just to illustrate that you will not be able to close out these claims necessarily as quickly as you could otherwise. However, you do have the other benefits. So you have to weigh that. You have to potentially choose between the cost of savings and the duration of the claim. You may not be able to have a short duration and cost savings. You might have to pick between one or the other. Also, if you have a large consolidation and a larger carrier steps in, there's some belief that you might be subordinate to them, that they might have more sway because they have 10 times more cases than you, into what discovery is necessary, things of that nature. We've also seen an emergence of what's called a liaison counsel. It doesn't exist in the labor code, but it does exist under the rules of court where an attorney tries to be appointed as a liaison attorney over all carriers, and there's some concerns justifiably for a lot of carriers involving that because they're not quite your loyal and duly chosen attorney. They're the attorney for multiple parties, and while there might be a common enemy, there may be a divergence of common interests. If you're a smaller player, that provider might offer you a sweetheart deal to get you out of the entire litigation. And if you have the same attorney as the larger carrier who's not being bought off, that might not be in your interest. So keep in mind that there is some risk of subordination. It's not true subordination, but the bigger dog is probably going to have more say than the smaller. So keep that in mind as well. You can try to keep your consolidation separate from the other carriers, but ultimately it's up to the board whether or not they want to allow other parties to specially appear or join in your consolidation. Keeping in mind, their goal is judicial efficiency, not necessarily the best outcome for the defendant or the provider. So I'm going to go through some quick examples here just to kind of illustrate what I'm talking about. These are not exhaustive examples, but these are some examples that have come up in my career and in dealing with these that'll help illustrate, I guess, what I'm talking about. So in example one, you have over 1,000 cases involving one service provider who has engaged in very suspicious activity. They utilize litigation costs in each case to leverage settlements above the initial invoiced amount. You find yourself going to court where they're demanding $1,500 when the amount in controversy is $90. They'll not comply with normal discovery efforts. They won't produce witnesses. They'll object to any subpoena you issue, thus driving up costs and furthering their leverage of your litigation costs to extract settlement. And you can't verify that the services rendered or even performed or even requested because they won't even provide request forms. So the issues here are that there's adjudication across multiple district offices. There's a lack of predictability to outcomes because you win in one board and lose in others. The amounts in controversy individually don't justify the cost of litigation. And I did write a blog article and actually was interviewed by WorkComp Central about this exact issue. We should be thinking globally about these. If you have a provider doing something in 3 of your cases, they're doing it in 3 of the persons next to you and the persons next to them. And if you were to look internally, you would find they would be doing it across thousands of cases. So keep that in mind. And then the trial judges, as I mentioned before, pressure settlement because they don't want to try the issue. They feel that the amount in controversy is not worth their time. And that's by design. The providers do that in order to get money that, again, they otherwise would not be entitled to. It's a business for them. The service provider will not even negotiate their originally invoiced amount. They want the originally invoiced amount plus penalties, plus interest, and plus some absurd number of costs and attorney's fees. So your strategic goals in this instance are you want to compel discovery across all cases. You don't want to be fighting to compel discovery in each individual case across the state because nothing will ever get done and you're throwing good money after bad. You want to put all of the discovery enforcement motions in front of a single judge to show a pattern of conduct by the provider, that they're acting in bad faith, that they're not complying with your discovery rights and that they're not following the rules of the board as far as discovery, even though they're billing under those same very rules. You want to mitigate your trial costs and discovery costs. You want to reduce them. You don't want them to have the leverage of saying, hey, it's going to cost you $5,000 to go to trial over $2,500, so just give me the $2,500. You don't want to deal with that. You also want to provide a global picture, a pattern to the same judge. You want the trier of fact to see this business pattern in order to make your argument that you not only do you not owe them money, but they may owe you money, restitution for their past conduct. You also want to prevent collection proceedings outside of the consolidation. You want to make sure that any future services fall under the same consolidation in our state. And maybe that deters them from future services, but it certainly deters you from having to relitigate this issue into perpetuity. If successful on the merits, you're going to have an order of finding across multiple cases, hundreds if not thousands. And if they try to relitigate the same dispute, you can argue for sanctions and various other remedies. If appropriate, you can have permanent stay orders, injunctions, whatever, potentially even referrals to the Department of Insurance Fraud Unit from a judge. And then you have res judicata, as mentioned before. So you have an order that operates similar to an en banc, at least with regards to this party that they are bound by, so they can't relitigate. There are some hazards you would need to consider in this fact pattern. You have significant front-end adjudication. They're not going to want the consolidation. They're going to make it difficult. You're going to have to go to multiple hearings, potentially spanning a year before you even get to issue your first subpoena. So keep that in mind. You're also not going to be able to resolve these individual disputes. In this example, when you're talking about a provider, you bifurcate that from the case in chief. You are not going to stall settlement of your case in chief because of the bad faith actions of the provider. So in this case, you would ask for that issue to be consolidated and bifurcated from the case in chief. And the board will appreciate that because they're not going to want to jam up injured workers receiving benefits because of a provider. There is complicated discovery. Again, I mentioned that there might need to be a third-party discovery management vendor and costs associated with that. Some carriers, if you look to your civil side, I'm sure in these general liability policies on the commercial side, your litigation department on that side may have internal procedures to deal with this, and they might allow you to borrow some of their cloud space and things of that nature, but you may need to involve a third party. Also, if you lose, and this is something that's dragged out over the course of several years, you do have compound interest in these disputes. You also have a very complex trial, and the other side is not going to be, if you win, the other side is not going to be happy with the outcome, and if you lose, we're likely appealing on your behalf. So you're looking at second reviews, third reviews, and any attorney handling this on your behalf should be in regular contact with their appellate attorney from the outset, so that any trial is teed up to preserve issues for appeal and properly frame them. Also, the internal review, I alluded to this earlier, gathering the information just to file your petition to consolidate is very time consuming. Doesn't mean you should not do it, but it is time consuming. There's various ways to do it, and we'd be happy to talk to you about that offline if you have any questions in that regard. All right, so you've now changed the amount in controversy from $2,500 across 400 cases to $100,000. You also have a potential restitution amount of $725,000. This was never been done before, so this is a matter of first impression. You may not recover it, but it is something to seek. If you have to fight the fight, you might as well ask for restitution. The projected litigation and discovery cost now is $80,000. There's a high probability of success or favorable settlement, so now your cost-benefit analysis makes sense, especially if you win anything or receive concessions on the restitution issue from the other side. So in that case, the cost-benefit analysis may make sense to consolidate. And some clients do believe so, others are a bit on the fence. So again, that frames that issue for you. The second example alludes to the industry trend with on the broker side, and you're going to be seeing this more and more, where you have a plant closure due to COVID-19, every employee was laid off. Upon reopening, very few of them came back. They already got reemployment somewhere else. And now almost all of your workforce is new hires. After 3 months, the plant has to close again because of a new COVID variant. All current employees have to be laid off again. You then get 40 claims alleging cumulative trauma psych injuries. So this somewhat follows the Cherokee case, but in newer, more modern facts. They were all filed by the new hires and they were all denied. So you have a large volume of potentially non-compensable claims, and there's going to be a large premium increase for your employer. And again, this is on par with Cherokee. You also have the unpredictability in case outcomes because you have multiple district offices and judges, and you also have variable litigation strategies based on those judges. Any attorney that does not modify their litigation strategy based on a judge needs to reevaluate that. We definitely determine what issues we want to try and how we want to frame them, in what order we frame them, based on our trial judge, and your attorney should know the judge. The unpredictability in case outcomes and adjudication costs also provide settlement leverages to the AAs and the injured workers. You might be settling these post-term psych claims for $30,000 because you have a bad judge and a bad QME. Whereas if you have consolidated these, that may not be the case. You also have the claims spread against multiple attorneys and claims professionals, even multiple law firms. And that provides for a potential less efficient administration of strategy, reporting, claim review, adjudication, things of that nature. So your strategic goals in this case would be to minimize the impact of non-compensable claims on the employer's experience modifier. You also want to provide predictability of outcomes on the post-term defense. You have a 6-month preclusion on psych claims in these cases. There should be no viable psych injury absent some sudden and extraordinary event. But if you have various judges, they're going to find differently. And we've all appeared at venues where there's a judge you cannot win in front of, no matter what. You also reduce the non-allocated costs borne by you because you have a single trial on all the common issues, in this case, the post-term defense. And you also don't have to worry about piecemeal settlement of provider liens across all cases, because if the cases are all consolidated on that affirmative defenses, so would all liens. And every lien provider would be barred from recovery if you prevailed on that issue. You don't let them, you don't allow them to do the same thing and leverage whichever judge or litigation costs into a settlement that they shouldn't be entitled to. The consolidated cases reside with fewer handling attorneys. So again, your claim review process will be much quicker. Getting reporting from the firm, the account team at the firm, your spreadsheet reports to provide updates to the employer and the broker will happen much, much more quickly because you have one standard format from one firm and one team of attorneys. Now, there are some hazards. If you get consolidated in front of a bad judge that you don't strike for whatever reason, one loss would be applicable to all, and you would lose all leverage to settle cases, presuming they would be denied. Applicants' attorneys on a case who might think they had a losing case now know they have a winning case and they're going to want more money. The AAs who are losing home field advantage, they're going to resist. You're going to have to potentially deal with a removal petition and respond to that. However, I don't see how losing home turf advantage is an irreparable harm. You know, the labor code is the same labor code in Van Nuys as it is in Reading, as it is in Sacramento, right? And in theory, all judges should be consistent in their findings because the law is the same universally across all district offices. Also, if you consolidate under these facts and you have a really, really intelligent applicant's attorney and it goes poorly, and let's say they have 15 cases and they get a huge attorney fee award, they may decide to start up a cottage industry and seeking out these types of consolidation via billboards and things of that nature. As far as non-strategic consolidations, any of these examples, if you replace them with defective defenses or bad facts or bad law, it's just not going to benefit you. So we need to really pick and choose. You know, there's always a saying, we don't want to make bad law, but we also don't want to make bad industry precedent. So consolidating every case for savings today while disregarding tomorrow costs is never a good strategy. Those are non-strategic consolidations. So we want to make sure that a proper cost-benefit analysis is performed and the risks and hazards are reviewed. So how can you identify strategic consolidation? You want to determine things like, are you going to pay off the provider because you don't want to pay litigation costs, which are higher? That's a red flag, and you may want to consolidate so that you can eliminate that consideration from your set of facts. Does the actual dispute involve the injured worker or provider? Well, if it involves multiple injured workers, then there are going to be better arguments to resist consolidation. If it involves a provider providing services across the entire state, they're not going to have as good of an argument to resist consolidation. Was there a large plant closure or a single incident resulting in multiple claims? If there were, it may be raising that flag of catastrophe, and you don't want to be caught off guard when the broker comes calling asking for you to report this all as one claim. You want to be able to respond indicating that you've done the analysis and why you do or do not believe that's appropriate, or that you already have taken steps to effectuate that. Generally, if the dispute is caused by the same party in several claims, it's the same is true across the entire state. If you just always have a case on your desk with the same provider, just doing things that seem unconscionable, so does everybody else. And it's widespread and systemic. And that is a case that is ripe for consolidation. Will the opponent agree to consolidation? If you can get parties to agree to consolidation, that's great. Usually when you want to do this for a strategic reason, the other side is not on board. But if they'll agree, then that might be a good thing. If they won't, then maybe it's the right strategic decision. So hear them out, but if they really don't want it, it's probably because it benefits you and not them. And also, what board will preside over the consolidation? Quickly, I just want to describe the process of what happens when you file a petition to consolidate. If it's at the same district office, that petition goes to the presiding judge, and they have a hearing, and everybody gets to say why or why not the case should be consolidated. However, when you're consolidating across various district offices, the board where you filed the initial petition to consolidate goes to the presiding judge. That presiding judge then provides that petition to their regional associate chief judge. That is regional associate chief judge then reaches out to the chief judge, and they determine where the case should be consolidated and whether or not it should be consolidated with the special adjudication unit or some other judge. And they typically will send these down to Southern California from Northern California, or in the district office where the majority of the cases are held. So that's the process in determining typically what board will preside. If the majority of your cases are in Van Nuys, odds are you're going to be in Van Nuys. So keep that in mind when also determining whether or not it's the right strategy for you. You always want to ask yourself what strategic goal you're working towards. What do you want to accomplish? Always ask yourself that. Don't consolidate just to slow something down. Don't consolidate just to jam somebody up. You have to have a goal in mind because it gets complicated and you want to make sure you're consolidating for a purpose, not just to slow things out, for a strategic purpose, not just to slow things down. You always want to ask yourself what bad can happen. What are the hazards? And I'm sure we all do that, especially attorneys. We worry way too much. And also the probability of whether or not you're going to achieve your goal or not. And again, consolidation just to delay may not be the best outcome because 7 years from now, you may be paying a higher amount than on the front end when everything's said and done. And you always need to ask yourself whether or not the cost-benefit analysis is favorable. So wrapping it up, there's many prospective benefits for consolidation, complex case designation, and strategic. You always want to pursue them on favorable cases. You don't want to pursue them on cases with bad facts or law. It's discretionary. The large consolidations are reviewed by regional chief judges and even Page Levy. So if your consolidation is for an improper purpose, the eyes on that are going to be very high up, and the reputational harm that can result will not be good. People who have direct lines to other people will be reviewing it, and you want to make sure that all of your arguments and reasons are outlined and that nothing material is omitted. Consolidation should not be pursued for an improper purpose. So not just to save money on premiums, not just to wait out somebody and bankrupt them. You need to have a good set of facts or a valid common issue of fact or law that you actually intend to adjudicate if you can't settle the case. Any consolidation needs to be for a strategic purpose. You make sure there's a targeted benefit that the consolidation is likely to provide. If there is not, then it can wind up being something you regret years down the line and feel it was a very bad mistake. So in that, make sure when you are consulting with either myself, somebody else at B&B, or somebody internally, you make sure to deliberate over time and weigh out any of the foreseeable hazards and factor out the actual benefits financially that you're looking to gain, and make sure that discussion is had, and make sure that whoever's providing you with counsel understands what your actual business objection or business objective is. With that, they're very unique. Every single one of these is unique to themselves. There is no one size fits all. Please contact me anytime. Here's my contact information. Email me or call me anytime, even if you just want to run something by me if you were considering it. And with that, you can also reach out to any Bradford and Barthel attorney that you have a closer relationship with, Tamina or anybody else on this presentation. Please reach out to us, whether it's going to result in a file referral or not. So with that, I don't know if we have any questions for the group. David or Lewis, do we have any questions?
Yeah, Patrick, there was one that I answered already, but I'd want to maybe add a twist to it to get your input as well. But this was from Kimberly Look. She asked, what if a case is already consolidated, but we were brought in as another defendant later in the proceedings? Do we have the ability to try and object to the judge? And my answer was yes, you have all the rights that you would normally. But the other question, I think, or the nuance that this brings up is, what is the time frame, perhaps, to object? Let's say the consolidation was a year ago, and you're brought in along with all your other cases. Is there a time frame to object at that point?
Well, the time frame to object to the consolidation would be the regular time to remove the order consolidating. However, let's frame this differently. Maybe it shouldn't have been consolidated in the first place, but is your argument against consolidation different now is that consolidation may not always be continually right. It can lose rightness. It may have been right to consolidate a year ago. Maybe it wasn't, but that's not your position. Your position is maybe this was the right move a year ago, but it is no longer the right move. The due process rights of parties has changed over that year, and consolidation is no longer viable. So that, I think, would be the better argument. But no, if you're hit with a consolidation order, you disagree with it, you need to file a timely petition for removal of that order.
Yeah, that was kind of the second question I was going to bring up to see if I get some debate going, but which is, what is the proper form of challenge? Is it reconsideration or removal? And because this is
File both.
I think you answered correctly, I think, at least in my opinion, that this is a non-final decision. It doesn't adjudicate any final rights. And like you said, it is kind of a moving target where you can review the ripeness or the appropriateness of that consolidation down the road, in fact. So I think it would be subject to removal, but that brings with it the added burden of arguing substantial prejudice or irreparable harm, which I think dovetails with what you were saying earlier about the need to show that there are dissimilar facts or the body parts don't overlap perfectly, some sort of basis to dispute the consolidation in the first place.
And my guess for Kimberly is that somehow something's changed in the medical legal record. And that's why consolidation wants to be avoided now. And we had nothing to do with it and to begin with, right? Because you were joined late in the case. Yeah, I mean, keep in mind that if you start pushing, there can just as simply be an election, right? An election against the party who's on board with the consolidation. So yeah, I think the argument would be that somehow the situation's changed and the due process considerations are different than they were when the consolidation order initially issued. Any other questions that came up?
No.
I want to thank everybody. This was a unique one for me. You know, I've been going around, I've really been hammering the non-IBR stuff since 2016. I've been going everywhere in the state, screaming at the top of my lungs, hey, we need to do something about this. And, you know, so we get into strategy sometimes with these presentations, but this is my first that is primarily strategy. So I hope it was delivered well. I hope that it engaged you, everybody, in thinking. And again, please involve me in any questions you have. I really look forward to seeing this evolve.
Thank you, Patrick, and thank you, Lewis and David. And Kim says, I appreciate the discussion. And I just want to add a few details here at the end. Again, just as a reminder, if you want to look at today's PowerPoint presentation, you can go to our website at bradfordbarthel.com. And thank you so much for joining us today. I hope that you all have a wonderful holiday weekend. Take care, everybody.
Everybody be safe. Have a great weekend. Bye-bye. Thank you.